6 or 7 categories: retiree health care, benefits administration, investment, collective bargaining, domestic relations, Freedom of Information Act, and Open Meetings Act. This summary itself includes 28 cases in total. I'm only going to touch on about 19 today. For the sake of brevity, I'm trying to keep this under an hour so you all can get back to your day. But with that, I will jump in, and I'm going to start with retiree healthcare, primarily because this has been the hot button issue for the past several years, going back to 2015 with the U.S. Supreme Court case in Tackett. We talked about that at the 2016 spring conference. If you recall, Tackett was the case where the U.S. Supreme Court essentially said that if collective bargaining agreements are silent regarding the duration of retiree health care benefits, that they are only required to be provided for the duration of the collective bargaining agreement itself, that they're not lifetime benefits. And that was interpreting a Sixth Circuit Court of Appeals opinion, which includes Michigan. Michigan is included in the Sixth Circuit Court of Appeals. And there was a little gamesmanship that went on over the next couple of years with the Sixth Circuit basically saying, okay, well, if the collective bargaining agreements are silent as to the duration of retiree health care, we're going to look at other provisions in the collective bargaining agreements. And in the case the case called Reese, the Sixth Circuit said, well, other provisions in the collective bargaining agreement seem to imply that retiree health care benefits were intended to vest for the lifetime of the retirees. And that case went back to the U.S. Supreme Court, and the U.S. Supreme Court said, no, that's not how it works. You can't read intent into provisions in a collective bargaining agreement unless they're ambiguous. And so the Supreme Court, again, citing Tackett, said, you know, because the collective bargaining agreements didn't specifically say that retiree health care benefits were lifetime benefits, that they only were vested for the duration of the CBAs themselves. During that time, I think when I presented those cases at the spring conferences, I made the point of saying we hadn't really seen this trickle down to the state level here in Michigan. And so what we're going to see with these next 5 cases or so, 4 cases, I think, is that trickle down effect where we've seen the federal cases apply in the state of Michigan. So with that, we'll start with case Price v. Charter Township of Bloomfield. And we have a pretty typical fact scenario here in retiree healthcare cases. The township made unilateral changes to healthcare benefits for retirees, and the retirees sued, claiming that that violated their collective bargaining agreements. The township argued, right, based on the federal courts, that the obligations didn't extend beyond the duration of the collective bargaining agreements. But here, in this case, the Michigan Court of Appeals actually ruled in favor of the retirees and looked to other provisions in the collective bargaining agreements and said that those implied a lifetime vesting of retiree health care. And in particular, the collective bargaining agreements contain survivor provisions that recognized a right to retiree health care benefits even after the retiree's death for a surviving spouse, and benefits for deferred or vested former members when they became eligible to retire. But what's important, and I want you to take a note, right? This case was issued on May 28th of 2019. 2 days later, on May 30th, Michigan Supreme Court issued the case Kenzierski versus Macomb County. And you may have heard of this case. This is essentially the law of the land in Michigan now regarding retiree healthcare vesting. And what the Supreme Court did essentially was adopt the federal law. They adopted the Supreme Court opinions in Tackett and Reese and said that, if a collective bargaining agreement is silent regarding the duration of retiree healthcare benefits, then those are not lifetime benefits. So in this case, you actually had 1,600 retirees that sued, claiming they were entitled to lifetime retiree health care. And the parties agreed, right, that the CBAs were only 3-year agreements and that they did not include a provision that specifically said retiree health care were lifetime benefits. And the Michigan Supreme Court, in a 5-3 decision, ruled that Tackett and Reese were controlling because Michigan principles of contract law were consistent, and that the collective bargaining agreements were not ambiguous, even though there were provisions that could have been interpreted to provide for healthcare, retiree healthcare after the collective bargaining agreements expired. So those survivor benefit provisions, or those deferred retiree provisions, or termination of retiree health care when a retiree failed to enroll in Medicare. The court said, even though those could occur, those occurrences could happen after the collective bargaining agreements expired, they could also happen during the duration of the CBA. And so the Supreme Court said that does not create ambiguity. The CBA doesn't provide for lifetime retiree health care, and therefore the retiree health care benefit is only good until the agreement expires. So the next couple of cases, we're going to really see the impact of the Kenzierski case. Allen Park Retirees Association v. City of Allen Park. This case arose out of the City of Allen Park's status as financial emergency. They had an emergency manager that altered retiree health care benefits. And so procedurally, there was some lawsuits against the emergency manager. But ultimately, this came down to the city's decision to continue providing the altered retiree health care benefits even after they exited the financial emergency. And the retirees sued, saying they were entitled to lifetime unalterable retiree health care. And ultimately, this case was decided by the Court of Appeals after Kenzierski, so they sent it back to the trial court saying, render a decision in light of the Supreme Court's Kenzierski decision. So I don't know if that has happened, but my inclination is that the retirees were not going to be successful in this case. Another case subsequent to Kenzierski was City of Wayne Retirees Association v. the City of Wayne. Again, the typical fact scenario, right? City made changes to healthcare. Retirees sued, alleging that they were entitled to lifetime healthcare that couldn't be changed. But here, the retirees made what I thought was a pretty good argument. They argued that there was a past practice because the city had honored the retiree healthcare obligations beyond the duration of the agreements. They had continued to provide the existing healthcare benefit even after a number of CBAs had expired. But I like the retirees, I would have been unsuccessful. The court did not agree. The court said, no, past practices only apply to CBAs prior to retirement, and that the retirees failed to show that there was mutual agreement that the retiree healthcare benefits would not be altered after the collective bargaining agreements expired. Basically, the court said, look, the city was extending you a courtesy by providing those benefits even though the CBAs had expired, and they had no obligation to continue that indefinitely. The last retiree healthcare case I want to talk about, this is back to a federal case. And this case is interesting because it involves a letter of understanding that specifically included language that retiree benefits vested for life on commencement of retirement benefits. And so in this case, Michigan Education Association Family Retired Staff Association, that's trying to say that twice fast, v. the MEA, was actually, it was a preliminary opinion in the sense that the retirees were seeking to obtain a temporary restraining order. They were seeking to stop their former employer from changing their retiree healthcare benefits before they could. They wanted the court to issue a TRO doing so, and they relied on that letter of understanding in support of their position. The court refused to grant the TRO, and the court said, you know, look, you submitted this LOU, but you didn't attach it to any specific collective bargaining agreement. So we don't know what specifically, you know, what provisions of the bargaining agreement this LOU was actually intended to amend. So we'll keep an eye on this case. Again, this was a preliminary order from the district court. We'll see what happens from here if the retirees are able to provide some more evidence in support of their position. I have a feeling we'll probably see this case in a future legal update. So before I move on to the next category, I'm going to stop there and see if there are any questions about the retiree healthcare cases I've covered. Okay.
I don't see any questions at the moment, Aaron.
All right, thanks, Lori. So I will move on then. So our next section is benefits administration cases, and there's 5 cases under this category as well. And these cases involve, as you might expect, plan administration, administration of retirement benefits, administration of retiree healthcare benefits, and there's actually a couple private sector ERISA cases in this section. I want to just emphasize, right, those are not binding law on public sector plans, but they're a good source of authority, source of information for us, because they typically involve similar scenarios that we deal with, right? Plan provisions, administration of plan provisions, fiduciary obligations. So I will touch on those cases or remind you that they're private sector cases, but I also try to relate those back to you as public sector trustees. So the first case here is Wilson v. City of Ferndale. This was a mandatory retirement case. City of Ferndale's police and fire retirement system had a mandatory retirement provision that required its police officers and firefighters to be retired at age 60. And that's not uncommon. Most police and fire systems have some sort of mandatory retirement provision, but in this case, Wilson challenged that mandatory retirement provision, number one, on the basis of age discrimination, which was denied. The Age Discrimination and Employment Act specifically authorizes mandatory retirement provisions for law enforcement and firefighters. So that was not a winning argument. But more interesting and relevant for us is that he argued that he was not subject to the mandatory retirement provision because he had opted out of the city's pension plan in favor of a defined contribution retirement plan. And the court disagreed with him and said, well, this, you know, the city's plan, which was a charter plan, so the provisions of the charter specifically recognized that all sworn police officers and firefighters of the city were members of the plan. And so he was a member of the plan and subject to its provisions, including the mandatory retirement provision. So his claim was denied. Clark v. Ford Motor Company and Ford Motor Company General Retirement Plan. This is the first of those 2 ERISA cases that I mentioned. This is an interesting case. It involves correction of errors in the administration of a retirement plan. It's a complex fact scenario, so I'll try and keep it brief. Mr. Clark was obviously an employee of Ford Motor Company and a participant in their retirement plan. And he was exploring his options under an early retirement incentive that Ford was offering its salaried employees. And during his exploration of that early retirement option, he learned that a supplemental benefit that he had opted into, essentially an additional 1.5% voluntary contribution that he wanted to make, had been stopped from 2004 until the time he was exploring early retirement in 2017. And so when he questioned Ford on that, they told him essentially, we don't know what happened. We'll look into fixing the issue. Well, as you might expect, Mr. Clark and Ford had different interpretations of what fixing the issue or working on fixing the issue meant, because Ford reinstated his contributions in 2017, but did not go back and make up any of the missed contributions that Mr. Clark would have liked to have seen. So he sued Ford and the retirement plan for breach of fiduciary duty. And the court refused to dismiss his claim, even though Ford argued that the individual that told him they would work on fixing the issue was not a fiduciary, was not a member of the retirement board. The court disagreed and said, well, he was representing the company, he was representing the retirement plan when he talked to Mr. Clark, and so there was a reasonable belief that he was acting in a fiduciary capacity. So I think we can relate this back to us, especially you plan administrators out there who may not necessarily be a trustee or a fiduciary of a retirement plan, but have a role where you're involved in the day-to-day administration of the plan, and you might have communications with members and retirees that, we still have to be conscious of what we tell them when they have questions, when they have concerns. And so sometimes we've seen our boards address this through the adoption of board communication policies or plan communication policies on how we're going to communicate with the members and beneficiaries of the plan, and how we're going to handle situations where they have questions regarding plan administration. I also probably, thinking about this case a little bit, I kind of think the court was trying to encourage settlement of the case. Both parties were somewhat at fault. Ford obviously erroneously stopped making the contributions or stopped pulling the additional contributions. Mr. Clark, as Ford argued, should have recognized that when his, biweekly paycheck increased. So I think the court's decision here was probably somewhat in an effort to encourage settlement between the parties. So the next case, another Ford Motor Company case, another ERISA case. I don't know if any of you are employees of Ford, but you might want to check on your retirement benefit. This is an overpayment case. So this was an overpayment of benefits by Ford to Miss Zerbell, and she was overpaid approximately $250,000 due to Ford's use of an incorrect benefit commencement date. Essentially, they paid her retroactively back to the date of her ex-husband's retirement rather than the date she actually applied for benefits. So they overpaid her about $250,000, and they tried to get it back, as they're required in accordance with their fiduciary duty and their plan provisions, so specifically required repayment of benefits. And Mrs. Zerbell claimed that she fought it, she appealed it, she went through the appeal process with the retirement committee. They denied her appeals, and they sought to recoup the entire $250,000, and that's when she filed the lawsuit and claimed that their refusal to reduce the amount to be repaid was arbitrary and capricious. And the court disagreed and ruled that the committee's refusal was not arbitrary, not capricious, because the plan provision specifically required the repayment of overpayments. Important to note here that even though in her lawsuit she claimed that the committee was acting arbitrarily by refusing to reduce the amount she owed, the committee had included in the last appeal denial letter sent to her that she could submit a written request for a hardship reduction in the amount to be repaid, which she didn't do. So I think that was probably her downfall, is that she essentially failed to exhaust all of her administrative remedies before she brought the lawsuit. Vanderholt v. City of Dearborn Employees Retirement System Board. Vanderholt, this is a deferred retirement case, I'll call it. Vanderholt was the surviving spouse of a vested former member who had applied to the retirement board for deferred retirement benefits. And the board actually received his application and approved his deferred retirement upon his attainment of age 60. The plan required him to be 60 years old to start receiving a pension, a deferred pension. And about 1 month prior to reaching age 60, Mr. Vanderholt passed away. And so the board said, well, he was never in receipt of pension benefits. We don't have an obligation to provide a survivor pension to his spouse. And here the court ruled in favor of the spouse. Ms. Vanderholt was awarded a survivor pension. And I think Ms. Vanderholt's attorneys, I think, pulled on the heartstrings of the court a little bit, because it went a little bit out of the way to find a way of awarding her benefits. It basically said, well, he had applied and his application had been approved, so he was in the process of receiving his pension when he died. And they analogized that with the process of a wide receiver receiving a forward pass, prior to actually catching it, they are still receiving it, as well as a mortgagee, after the closing, they're in the process of receiving mortgage payments, even though they're not going to get one for, over a month, because that first mortgage payment is included in the closing costs. So interesting case, pretty liberal interpretation of the word receiving in the pension ordinance, but the court did rule in favor of the surviving spouse. Beck, the Michigan Public School Employees Retirement System. This case actually involves administration of retiree health care benefits and online enrollment. We're seeing this more and more nowadays, especially with healthcare and defined contribution plans. The administration is becoming more and more automated. Changes in elections can be made online. So what happened here was Ms. Beck had a deadline to make an election on her retiree healthcare benefits. She actually essentially had the option of choosing between a defined benefit type retiree healthcare benefit, where she would share, some of the costs, premiums and co-pays and deductibles, or a defined contribution type retirement benefit, where she would get contributions into an account that she could then use when she retired to pay for her benefits. And so she went online after she was notified, and then she was sent a notification letter, telling her, this is what you elected, confirming her election. She alleged that the election that was confirmed to her was not the election that she made, or at the least not the election that she wanted, and she sought to have it changed by the court. The court refused to change the election. And the court held that there was substantial evidence in support of the retirement board's conclusion that Ms. Beck had elected that option. There were online records indicating that she logged in on certain dates. There was a record of her election actually being made, and then there was her own testimony that, she didn't intend to elect that option, but if she had done so, it was through her own haste or computer error. Basically, she fat-fingered the wrong button, and elected the wrong option. But nonetheless, the court refused to change her election, and she was stuck with the option she didn't want. So I will pause again. Any questions at this point so far? No questions. I'm getting texts from my colleagues here, so.
Okay. Aaron, just on that Vanderholt decision, so is that set a precedent? I mean, could a defer vested person apply a year ahead of time in order to kind of lock in a benefit? Or should a board be very clear about how many days ahead of your vested benefit you can legitimately send an application?
Yeah, so that's a good question, Lori. It's not precedential in the aspect that it's an unpublished opinion of the Court of Appeals, right? So it's not, in my world, it's not precedential, it's persuasive, right? Another thing to keep in mind is a lot of retirement plans have a window that you can only apply, no less than 30 days or more than 90 days prior to your eligibility date. So I think in this case, that's what happened is, he applied 90 days out. The board received it and approved it. And then, between those 90 days, he passed away. No, I don't think it would open the door for deferred retirees to start putting applications in years in advance. Number one, I think plan provisions would prohibit that. Number two, I don't think that was, like I said, this was an unfortunate situation. He was a month away from it. I think the court felt sorry for his ex-wife and, really went out of its way to find a way to give her the benefit. So we're on to investment cases, and there's only one of these, and it's not particularly relevant in the public sector, but it is a United States Supreme Court case, so I included it. And even more rare than the fact that it being a United States Supreme Court case is that it's a unanimous Supreme Court case, which is almost unheard of nowadays, with the political diversity on the court. But this involved the IBM employee stock ownership plan, which we don't have in the public sector. Obviously, cities and counties and the state don't issue stock, but IBM does, and they had a stock ownership plan, and this involved a breach of fiduciary duty claim against the retirement board with respect to their handling of inside information regarding IBM. Basically, they did not divest themselves of IBM stock, even though they knew information detrimental to the company that would cause the stock price to drop. So they didn't do anything in light of having that information. And the Supreme Court basically said, well, there's a test. The Supreme Court recognized that, the fiduciaries of the plan don't have an obligation, number one, to violate federal securities laws. So they can't act on inside information, or they would be in violation of federal securities laws. But two, that there has to be an analysis done on whether their decision, whether it's a decision to do something or not to do something, caused more harm than good. And so they sent it back down to the lower court to do that analysis. But for our purposes, I think we can relate this to the fact that, look, the Supreme Court recognized in this case that there's a different duty to the members of the retirement board than they might have had as officers or directors of the company. So their fiduciary duty was separate than their duty to shareholders of the company. And we like to talk about this as wearing your trustee hat and not your union hat or your employer hat. So I think we can relate this case in that way to the public sector. Any questions about that one? I'm not expecting any, but I'll give you a minute.
No questions.
Okay. Collective bargaining, we do have one case involving collective bargaining. It actually involves composition of a retirement board. This is Wayne County v. Wayne County Retirement Commission. In this case, arose out of Wayne County's financial emergency when the county CEO, with his powers under the Emergency Management Act, local stability, I can't think of the name of it off the top of my head, but he basically settled terms of collective bargaining agreements with the county unions that changed the composition of the retirement commission, which was set forth in the county's charter and retirement ordinance. And part of those changes was a reduction in the number of employee representatives on the retirement commission. So they were losing one employee rep, as well as a reduction in the number of retiree representatives on the retirement commission. They were also going to lose one representative. And so the retirement commission challenged this action, basically arguing that the county couldn't implement terms and conditions of employment on non-union employees or retirees who didn't have a seat at the bargaining table. And the Court of Appeals refused to implement the changes to the retirement commission. And the court's decision was somewhat narrow, right? The county sought to what's called a writ of mandamus. Basically, it's an order of the court ordering a governmental entity or government official to perform a legal duty. And the Court of Appeals said, well, no, seating this new retirement commission was not a ministerial act that we could just order, because it involved significant decision-making beyond the scope of the court's authority. Specifically, how are they going to decide what employee rep was no longer a member of the board? How are they going to decide what retiree rep was no longer a member of the board? The new members of the board, how are they going to determine terms of office? How are they going to be appointed or elected to the board? So the court refused to seat the new retirement board, and the existing retirement board as set forth in the charter continues. Any questions on that one?
No questions.
Okay, moving on. Domestic relations. We got two cases, domestic relations. These pertain to administration of eligible domestic relations orders. And they're actually, I think, private sector cases, so they pertain to quadros. But for our purposes in Michigan, we call them EDROs. We are marital, or retirement benefits are marital property in the state of Michigan, so we are required to split them between parties to a divorce, provided they, comply with all the legal requirements and comply with the plan provisions. So we'll talk Heischetter v. Tyson Foods. Parties got divorced, and their judgment of divorce included some language that we see quite often. Said each party shall receive free and clear from any interest of the other all pension, annuity, retirement benefits which he or she has accrued as a result of their respective employment. And basically, that's a fancy way of saying, now, nobody's entitled to each other's pension. Nobody's entitled to each other's retirement benefit. And we see that quite a bit, and usually that's the end of story. We see a judgment of divorce with that language. We know we don't have to worry about administering an EDRO or a domestic relations order. But in this case, what happened was, even though the parties agreed to that in their divorce, Ms. Heischetter, subsequent to the divorce, went back to her ex-husband's employer, Tyson, and asked them to provide her with a retirement application. And they refused to do so, and she sued them, and the court said, well, no, they don't have any obligation to give you a retirement application. You're not a beneficiary of the pension plan on account of your divorce, and you're not an alternate payee because there's no, in this case, it would have been a quadro, but there's no domestic relations order awarding you a portion of his retirement benefit. So it was a pretty straightforward case, but I thought it was relevant because we do see this language a lot of times in judgments of divorce, and we rely on that for the fact that the ex-spouse doesn't have a claim to retirement benefits. Next case under domestic relations, Dorco v. Dorco. This is actually a Michigan Supreme Court case. We don't too often see domestic relations cases go to the Michigan Supreme Court, but this one did. And the fact scenario here is pretty relevant. The parties were divorced in 2005, and then in 2015, some 10 years after the divorce, Mrs. Dorco sought to get a quadro entered by the court, and her ex-husband argued that that was barred by the statute of limitations on non-contractual money obligations. There's a 10-year statute of limitations in Michigan on payment of non-contractual money obligations, and he argued that applied here. Supreme Court disagreed, said that an action to seek enforcement or seek entry of a quadro is simply seeking to enforce a provision of a divorce judgment and is not an action to enforce a non-contractual money obligation. So no statute of limitations. She could seek to get the quadro entered more than 10 years after the divorce. But the court did note that if she sought to enforce the quadro retroactively, right? If she sought to go back to 2005 and collect benefits that had already been paid to Mr. Dorco, that the statute of limitations would apply, and she would not be entitled to that money. So we've seen cases in the past where plans have had to pay benefits retroactively when EDROs get entered years down the road. And this is a potential defense to that. If you got one that gets entered more than 10 years after the divorce and you've already been paying the plan participant retirement benefits, you might be able to use this as a defense should the ex-spouse try to get benefits as well. Any questions on the domestic relations cases? How are we doing on time? Good.
No question.
Okay. Disability retirement, we have one case. It involves coordination of workers' compensation benefits. Oftentimes we see provisions in retirement plans that require duty disability retirement benefits to be offset against any workers' compensation wage loss benefits that the individual is receiving. And that was no different here. In this case, Bell v. Saginaw. The retirement ordinance did provide an offset of the duty disability retirement pension against the workers' compensation wage loss. So while Mr. Bell was in receipt of a duty disability retirement, it was reduced by the amount of workers' compensation wage loss benefits he was receiving. Now we also see, and this is a little bit more prevalent in police and fire retirement systems, which was the situation here, but we also see a recomputation provisions a lot of times when members attain a certain age or when they otherwise would have been eligible to retire, their duty disability benefit will be recomputed as an age in service retirement, and they'll take into account the years of service or the years that the individual was receiving duty disability benefits, and they'll include them in the service calculation in calculating an age in service benefit. So that happened in this case when Mr. Bell attained age 50. And when that happened, the city sought to reduce his workers' compensation benefits. And Mr. Bell argued that they couldn't do that because that wasn't a provision of the pension plan. And the court said, no, the city has the ability to do that. The Workers' Compensation Act, Michigan's Workers' Compensation Act, does contain a coordination of benefits provision that allowed them to coordinate workers' compensation with his age in service retirement benefit. So after his disability retirement was recalculated, the city was then able to reduce the weekly workers' compensation wage loss benefits because there's a coordination provision in the Workers' Compensation Act. Questions about that? We're getting down to the end here, so I'm on schedule.
No question.
Open Meetings Act cases, there's a couple of these. One deals with what constitutes a public body under the Open Meetings Act. The other one deals with closed sessions. Both, I think, are relevant as, retirement boards are public bodies subject to the Open Meetings Act, and we do occasionally have to go into closed session. So the first case, A Felon's Crusade for Equality, Honesty, and Truth v. Detroit Public School Board. I think I like this case just for the creativity in the name, although as a legal strategy, I'm not sure how sound letting the court know you're a convicted felon is. It didn't play out too well for the plaintiff in this case, but basically I'll refer to it as the Crusade. Alleged that the Detroit School Board violated the Open Meetings Act throughout its search for a new school superintendent. And what the school board did was they created a search committee comprised of 3 members of the school board, which was less than a quorum, to conduct basically a search process, right? An investigation, review of candidates, and then that committee provided the full school board with a report of its findings, and that included a recommendation. And then the full school board acted on that recommendation and hired a new school superintendent. Well, the Crusade alleged that the the school board violated the Open Meetings Act because the search committee's meetings or the search committee's actions were not open to the public. They didn't have public meetings. There was no public comment. There was no public participation in that process. And the court ruled in favor of the school board and said that no, the search committee was not a public body subject to the Open Meetings Act because they were only advisory in nature. They only gathered and presented information of the full school board. They had no authority to act, and therefore they were not a public body subject to the Open Meetings Act. The next case is Meyer v. Oakland Community College Board of Trustees. And this is the closed session case that I mentioned. Here, the OCC board went into closed session with its legal counsel to discuss personnel matters pertaining to Mr. Meyer's employment as chancellor of the community college, which is perfectly legal. You can go into closed session to discuss personnel matters with legal counsel, subject to the attorney-client privilege. What where the board went awry is when they returned to open session, they simply approved the plan as discussed in closed session. And ultimately, the plan was to terminate Mr. Meyer's employment with the community college. And so he sued, claiming that they violated the Open Meetings Act by deliberating and making a decision in the closed session, which is a no-no. And the court did rule in favor of Mr. Meyer and said that the board did violate the Open Meetings Act because it did deliberate and did come to a decision in closed session. Although the court refused to reverse the decision terminating his employment, Mr. Meyer was entitled to statutory damages under the Open Meetings Act. So it's just important to remember that, even though you can go into closed session to discuss matters with your attorney or, discuss matters pertaining to, usually it's personal health information, things like that. Boards are not permitted to deliberate in closed session. You have to come out of closed session and have further deliberation if necessary, and your decisions have to be made in an open meeting. And that essentially didn't happen in this case. FOIA, any questions on Open Meetings Act cases?
No question.
All right, last section, Freedom of Information Act. We got 2 cases here too. One deals with redacting information in a FOIA response, and the other is a little bit more technical. It deals with some of the amendments we saw to the FOIA recently regarding posting your FOIA procedures online, and the authority of a FOIA coordinator. So McIntosh v. City of Rockford. This is the redaction case. The city failed to provide the written notice explaining redactions in the records that were provided to Mr. McIntosh in response to his FOIA. So it is a requirement. If you're redacting information in records, you had to provide some written explanation on, why those redactions were necessary. And the city didn't do that here. And McIntosh sued. The court, said, yes, that's a violation of the FOIA. The city can either provide the explanation or alternatively just produce unredacted records. City chose to produce the unredacted records and then asked the court to dismiss the case because it was moot at that point. The court did so. It dismissed the case, but not before imposing a $2,500 fine and awarding $8,750 in attorney's fees to Mr. McIntosh for violations of the FOIA. So, the simple failure to provide that written explanation was a $12,000 mistake. So we just, be aware of that requirement if you're ever redacting information when responding to a FOIA request. And our last case, Blau v. Alpena Community College. And this is the case that deals with some of the new requirements that were implemented in the recent amendments to the FOIA, specifically, the requirement that the FOIA procedures had to be posted online. So what happened was Mr. Blau submitted a FOIA request to the community college, and the community college's FOIA coordinator requested a 50% good faith deposit prior to producing the requested records. Again, perfectly acceptable. You're allowed to request that under the FOIA. But rather than just paying the deposit, Mr. Blau decided that he was going to sue the college, and he claimed these technical violations of the FOIA, namely that they didn't post the FOIA procedures prior to him submitting his request. The procedures weren't adopted by the college's board of trustees, And the court ruled, I think probably because these are pretty petty claims, he could have just paid the deposit and got the records. But the court ruled against him and said that, you know, the community college complied with the FOIA because they posted the FOIA procedures prior to responding to his request, and that the Board of Trustees didn't need to approve the policy because it had delegated that authority to its FOIA coordinator, which was permissible under the law. So community college was successful in that case. And that does it for the 2020 case update. I will stop and ask if there are any questions about any of the cases. I did manage to keep it under an hour. So like I said, lawyers don't lie. Well, thank you. Yes, thank you very much. I wish I could see you all, but you know, if I don't, everyone have a wonderful 4th of July holiday, and hopefully I see you all soon.
Thank you, Aaron, and you're getting kudos from participants on the chat, so good job.
Great, thank you very much.
Thank you. So this is the last in our series of webinars. We hope you've enjoyed them. If you've been able to participate in the earlier ones, if you haven't, the materials are located on the events page of the MAPERS website, and I encourage you to go look there. And also on our events page is all the registration materials for the fall conference on Mackinac. So if you have any questions about the conference, you can email Michelle Doran, and she will be happy to answer you. Okay, so on behalf of the MAPERS board, we wish you, your family, your colleagues, good health and safety, and we look forward to seeing all of you, as many of you as we can on Mackinac. Thank you very much.